Good evening and welcome. It's my pleasure to introduce the first ever presentation of selected works from the Maritime Law Journal. And before we get started with the presentations, I want to have just a minute to say thanks on behalf of the Maritime Law Journal, its members, and Tulane Law School. First, to Phelps Dunbar for providing the time and space for us to host this event tonight. Second, and this might be a mouthful, but bear with me, to the Admiralty and Maritime Law Committee of the ABA's Tort Trial and Insurance Practice section. I hope I got that right. But thank you for helping us put this event together, for publicizing the event for us, for making sure that it is being recorded right now and posted on your website so that we can reach as large an audience as we possibly can. And that brings me to a point I wanted to make about the objectives of the Maritime Journal in the first place. The main objectives of the journal, and I think of any law journal, are twofold. First, they are to edit and produce the best scholarship for us in the field of Admiralty and Maritime law out there. And I think it's beyond debate that for the last 40 years, that's exactly what we've done in extraordinary fashion. And the second of the core objectives of the journal is to produce the most and the best student-written material that we possibly can. And this program is a logical extension of that purpose. We want to engage the Admiralty Bar with our students so that we continue to have the presence that we've had for the last 40 years. And so I wanted to say a special thanks to Ray Wade for approaching me in the beginning of the summer to put this event together and for taking his time and his effort to be here tonight and to help publicize this event. And there isn't anything more I could say, but thank you very much for doing that for us. And last but not least, I want to thank my colleagues on the journal who are presenting tonight. I think, and I can't say this for everybody, but I can certainly say it for myself, it takes, there's a measure of anxiety to presenting your work to a group of individuals who have spent their careers practicing in this field. So I wanted to thank Katie Clements, Mike Dehart, Caroline Frilot, Phoebe Hathorn, and Imran Naeemullah for giving of their time and their effort to come here tonight and to have the courage to express their ideas about the law to this group. And that being said, since I have the pleasure of a last name that begins with an A, and because I'm already standing up here in front of you, I'm going to start off the presentations with a discussion of my comment, which concerns the Longshore and Harbor Worker Compensation Act, other adjoining area language, and the circuit split that goes along with that language. I'll give a brief background just so that everyone's on the same page so that they're not lost during this presentation. But essentially, there are two threshold criteria for coverage under the Longshore and Harbor Workers' Compensation Act. Those two criteria are, one, that the injured worker claiming coverage should have a maritime status, and in these cases, that never seems to be an issue. The second and important for this discussion threshold criterion is that the worker be injured at a situs covered by the Act, referred to as the Situs Inquiry, and that is the subject of this discussion. I came across this topic while looking at case note topics, actually, during the fall semester of my second year of law school, and I read the case and I felt that the material in the case was better suited to a comment than it was to a case note, because the court in its background section essentially breaks down the approaches of the different circuits that treat this issue. And so I decided to, rather than making that the focus of my case note, make it the focus of my comment so that I could expand the discussion to include these other circuits. And the circuits that I discuss, and these aren't all of the variations on the rule, but the circuits I discuss are the 9th Circuit, the 5th Circuit, the 11th Circuit, and the 4th Circuit. And essentially the test is the same in each circuit. It's basically whether or not the Situs Inquiry is met, but by a variety of methods. So just by way of background, the 5th Circuit uses totality of the circumstances test, and the 9th Circuit is beholden to that test for reasons I'll discuss. And and generally adheres to the test. It doesn't completely adhere to the test, but in addition, the Ninth Circuit employs a not less than 4-factor test, and the Fourth Circuit employs a binary approach to determining the Situs Inquiry. And so I will go through a little bit about each of them in the discussion, but I'm going to try and pare it down for the purposes of this speech. And if you're interested in hearing more about it, the comment will be available in December in the Maritime Journal's Issue 1, Volume 38. So basically, the primary focus of the case note is the case New Orleans Depot Services, which was reheard recently, but when I wrote the comment was based on a panel opinion of the Fifth Circuit. And what happened in that case is that a worker who was a container repairman working at a container repair facility about 300 yards away from the Industrial Canal here in New Orleans sustained a hearing injury from the prolonged exposure to loud noises at the facility, and filed a claim for compensation under the LHWCA, and that proceeded through the usual steps of worker compensation claims through the ALJ, the BRB, and up to the Fifth Circuit. And the Fifth Circuit based its decision in this case on a 1980 case of the Fifth Circuit called Texports versus Winchester, and in that case, the Fifth Circuit, sitting en banc, reversed a panel opinion of its own judges, holding that essentially the Situs Inquiry was based on a more specific set of factors. The Fifth Circuit en banc decided that rather than hedging the decision on whether or not the Situs Inquiry was satisfied on a set of labels or on any single dispositive factor, they held that the injury site must have some nexus with the waterfront. And what that introduced is a totality of the circumstances approach that focuses specifically or primarily on a number of factors, and those factors are the proximity of the injury site to the waterfront, the reasons why the employer chose to site its business there, and the character of the surrounding facilities. Now, that decision sat untouched, essentially, and when the Fifth Circuit split, the 11th Circuit, bound to hold to the precedent established by the Fifth Circuit before the split, sort of over time drifted away from that specific inquiry, and that subject is also discussed in the comment. But perhaps more importantly, the opinion lasted 33 years till last year, when a very similar case, and all of these cases, frankly, come up on similar procedural and factual backgrounds. But the case lasted until this past year in New Orleans Depot Services, where this worker injured his face, filed a claim, had his claim denied, and took it up to the Fifth Circuit. And the panel opinion held that he met the inquiry based on this totality of the circumstances approach. The employer appealed that decision, and the Fifth Circuit en banc decided to reverse the decision, and for reasons that I argue in my comment it should have. Unfortunately, the rehearing opinion came out prior to, but after I submitted the comment for publication, so I wasn't able to have an extended discussion of the Fifth Circuit's opinion. However, it, for what it's worth, ended up taking the approach I suggested that it should take, and that it should follow the Fourth Circuit's approach to resolving the Situs Inquiry, and that is the binary, either you adjoin the water or you don't, and so there is either coverage or there's not. And there are a number of reasons that I focused on for why I believe that is the most efficient, the best approach to resolving the inquiry. And the one I'll primarily focus on is predictability for employers. But the three were producing and sustaining judicial efficiency and predictability of coverage, and there was a last one that's escaping me at the moment. But essentially, the reasons why I believe that the approach should be that way is based on the predictability of coverage. The way that it was working, for instance, for an employer like the Clements employer in New Orleans Depot Services, was that they were siting their businesses close to a waterway for reasons completely unrelated to the waterway. A container repair facility can be 5 miles away from the water, or it can be 5 feet away from the water. And so, and this is what Judge Clement in dissent in the panel opinion for New Orleans Depot Services mentions quite a bit, but that it makes no sense to subject employers who site their businesses in these what are typically industrial zones next to navigable waterways when they're citing their businesses there for reasons completely unrelated to it being next to water. For instance, the environmental regulations next to navigable waterways are typically less restrictive, and the noise regulations are typically less restrictive. So what ends up happening is that the Act, and the way it's interpreted judicially, captures employers who have no connection to maritime work, who wouldn't meet the status inquiry, perhaps, but who meet the Situs Inquiry based on this fuzzy totality of the circumstances approach. And if you choose not to do it that way, and now the third reason I had is coming back to me, but the reason why, the third reason was because of the plain language of the statute and the legislative intent when the 1972 amendments to the Longshore and Harbor Workers' Compensation Act were introduced for the stated purpose of resolving the problem of workers passing in and out of coverage. And in dissent, Judge Clement in the panel opinion acknowledges this problem, that there is an issue with over-inclusiveness, and acknowledges that there could be under-inclusiveness, but explains that the legislative intent, and I believe this is in the Senate report to the 1972 amendments, acknowledges that there's going to be under-inclusiveness of the Act. It excludes those who clearly, for other reasons outside of Situs, would qualify for coverage under the Act merely because they aren't injured on one of the enumerated spaces or do not fall into the category of what is defined at the time as an other adjoining area. And so, in the interest of adhering to the plain language of the Act, which clearly contemplates an adjoining area, and in the interest of adhering to the legislative intent, the Fifth Circuit, and I argue all circuit courts, should adopt an approach that's binary. You either touch the water or you don't. And if you adopt that test, then employers know where they can cite their businesses and not have to worry about whether or not they need to purchase insurance coverage sufficient to cover an LHWCA claim. And it does away with the inefficiency of having appellate review of cases that normally would constitute an issue of fact for a trial judge. You're touching the water or you're not touching the water. So it is a more efficient adherence to the plain language and I think fairer for employers in terms of predictability approach to resolving this inquiry. And therefore, I would argue that every court should adopt this Fourth Circuit binary approach. Thank you.
Good afternoon, or I guess evening, as it may be, everyone. My name is Katie Clements, and I chose to write my comment on shipowner liability in the Bareboat Charter context, more specifically in a non-traditional charter agreement circumstance where liability remains unclear and injured third parties have been unable to recover. It was sort of derived out of a recent Eastern District of Louisiana case, Gabarek v. Lauren Maritime. Some of you may or may not be familiar with it. In general, charter agreements allow parties to allocate the cost and risks of doing business. While these non-traditional types of agreements are common, litigating these non-traditional agreements are less common, and therefore liability remains unclear. In a bareboat charter, there's usually a shipowner and a chartering party or a charterer, and the charterer takes full possession and control from the shipowner. The ship is directed by the charter's master and carries the cargo as the charterer chooses. The shipowner himself only maintains title to the vessel. Therefore, the charterer then bears all of the liability. In contrast, a time charter allows a party to basically lease a vessel's carrying capacity, and at all times the owner maintains operation and navigation of the vessel and bears the liability associated with those two. In my mind, I sort of associate a bareboat charter as being similar to leasing a car. I know that it's not a perfect comparison, but say you go to Ford and you lease a car. Ford at all times maintains title to your vehicle, but for many other purposes, you might be considered an owner of the vehicle. You pay a monthly leasing expense or cost. you put gas in your car, you get it dirty, you take it to the car wash, you care for it, that kind of thing. But at all times, Ford retains the title. In addition to that, there's no dispute that the driver is responsible for his or her own insurance. And further, if the driver gets into an accident that he or she will be liable for that as well. A time charter is more like riding in a taxi, where you're really just there for a limited purpose. The taxi driver maintains sort of operation, maintenance, control of the taxi at all times, and you're just sort of there for a limited, arrangement. Assume, though, that after you go lease your car from Ford, they contract back with you, and they say, over the next 6 months, we're going to pay you to drive this car only at our instruction. Therefore, you no longer get to drive it when you want and where you want it, but only according to our needs. In that case, say then the driver gets into a wreck or an automobile accident. There's no question that the driver's probably at some fault and going to be liable. The overarching question is whether Ford then should bear any risk or responsibility or liability, or whether they have absolved themselves from all liability simply by leasing the car to you. It's your car now. You got in an accident. You're in trouble. In the Dehart case, it was a collision case that resulted in litigation. ACL, Bareboat Charter, so this is the lease typo, a vessel which was a tug over to DRD, and then simultaneously time chartered it back to themselves for their own business purposes. So essentially, they outsourced a crew to operate and maintain their own vessel and to navigate it then according to their own instruction. The parties are in dispute because while DRD was navigating the vessel, they collided with an oil tanker and caused over $90 million, or I think approximately $90 million in damages. DRD only had $10 million in coverage, so that left $80 million on the table for the injured parties to try to collect somehow. There's a few other interesting facts to the case that my comment doesn't necessarily address. For example, the captain that DRD had assigned the vessel had chosen to get off the vessel, I believe somewhere around the Carolinas, because he had been tracking his girlfriend with a GPS tracking device and had realized that she had been at one of his friend's homes parked there for over 2 days. So he went to take care of the matter, leaving the vessel in the hands of an unlicensed operator who he had formerly tried to fire for sleeping on the job. DRD had also been involved in a number of incidents. In the past 15 months, I believe they had been in 17 accidents, or there was a number of incidents where perhaps they had had some rule-breaking circumstances. However, the court, said that ACL did use a vetting process and called it reasonable, albeit minimal and imperfect. Before the Dehart decision was made, there was another case in the Eastern District of Louisiana called Etheridge versus Subsea International. It was a Jones Act case, which was also included a bareboat chartering issue. However, there it was really an issue of whether operational control was surrendered to the charterer. The court then acknowledged that this operational control language, where you charter and give operational control to the charterer and liability shifts to them, created recovery gaps and caused problems. They further acknowledged that looking beyond the terms of the contract to things such as economic purpose, commercial reality, and unity of mission may have otherwise satisfied an ordinary meaning of control, so that this language that courts use is very limiting. But they declined to depart from their formalistic approach at that time. In Dehart, the court then chose to analyze this unique circumstance in a two-step, two-contract process. They said first, ACL completely shifted liability to the Pro Hoc Vice owner, DRD, in the first contract. And although they simultaneously contracted back, ACL shielded themselves from liability because that's what a bareboat agreement does, and that there was otherwise no definitional element that went unmet. They basically, again, acknowledged their temptation, however, to give the control language a, quote, more expansive and even realistic meaning, one that shows ACL's constructive control in directing the captain where to take the vessel, the reason for the assigned voyage, and ultimately the dedicated purpose for the mission, which was ACL's economic gain. So they recognize that this operational control doesn't even necessarily mirror the situation. Again, the court found, though, that the facts of this particular case did not allow for a more expansive view, and that the mere dispatching is what they called ACL's role. The dispatching to DRD was not enough to take away operational control from from DRD, the charter. In general, there's a circuit split on whether these bareboat agreements can shield ship owners from liability, and most case law is in the context of a vessel's unseaworthiness, where some third party is injured because of a condition that exists on the vessel. The Fifth Circuit, however, stands alone and has stated a ship owner may not use a bareboat agreement to limit liability for the unseaworthiness of a vessel. In dicta, they have indicated that this mere surrender of control component may not always absolve a ship owner from liability. The 11th Circuit has twice declined to address the issue. There are two Middle District of Florida cases, one being the Gatewood versus Atlantic Sounding, where they just discuss indicia of a bareboat charter not existing, whether the owner has ultimate control over the vessel or has, I think, unlimited access to the vessel. Those would be indications that a bareboat charter does not exist. And then the second case coming out of the 11th Circuit, Florida Court, is Lovett v. Happy Hooker, where they just say the ship owner failed to meet the heavy burden of proving a bareboat, but they even then acknowledge that this issue of ship owner liability is unresolved. The First, Third, Fourth, and Sixth Circuits allow ship owners to shield themselves from liability and only say ship owners are liable in the context of an unseaworthiness claim where the condition existed prior to shifting the vessel over to the charterer. And the Ninth Circuit has explicitly declined the Fifth Circuit's precedent. They say that a ship owner may absolve themselves from liability in the third-party context as well as in the charterer context. So I also addressed some negligence issues under the Shipowner Limitation of Liability Act, as well as some negligent entrustment issues under common law theories of negligence. I don't have time to cover those today, but you're welcome to read about them. However, the Fifth Circuit has stated, if a ship owner knows enough to be liable for negligent entrustment, he knows too much to be eligible for limitation under the Act. So unique circumstances may force courts to not only adopt the Fifth Circuit's sort of broader, expansive control analysis that they have suggested, but I even think turning to some common law theories of negligence would be more useful to some of these third parties. For now, the way things stand, injured third parties are left being unable to recover from insolvent and underinsured charterers such as DRD. Thank you.
Good evening, everyone. My name is Mike Dehart. I'd like to start off by thanking Ray and Yaakov for putting us together, and the ABA Torts Insurance Trial Practice. And I would like to apologize to the tips that my comment has nothing to do with torts, insurance, or trial practice, but I promise it will be exciting. So I wrote my comment on the harbor maintenance tax, and if there's one thing that everybody likes, it's a tax. If there's one thing that everybody likes more than a tax, it's a federal tax, which is what the harbor maintenance tax is. And part of the reason why I wrote this comment is because it's important the United States itself is at a crossroads as far as our infrastructure, roads, and ports and harbors are no difference. And there's a lot of faulty infrastructure. We can look outside here today and see some areas that may need some upgrade, and the harbor maintenance tax is potentially a very effective mechanism for addressing this problem and letting it not get to an ongoing concern to the point where the United States falls possibly even farther behind as far as our infrastructure with the rest of the world. And additionally, the expansion of the Panama Canal and Panamax vessels, I mean, the ports and harbors of the United States need major improvement, and I think that this is something that can really help out in that area. And additionally, this is a regulatory matter, and I'm the senior articles editor of the journal this year, and one of the things I talked about was expanding the scope of what we publish, and we don't publish that much stuff on regulatory concerns, and I didn't really assume this comment was going to be chosen for publication, but I wrote that with the back of my mind. So I'll talk a little bit about what the harbor maintenance tax is. And it was originally part of the Water Resources Development Act of 1986. And as originally drafted, it was at 0.04% of all imports and exports coming into the United States. and currently it's 0.125% of all imports coming into the United States. The tax is assessed on the importer of the goods, and it's paid when the goods come into the country. So when you arrive at the port, it's a fairly simple mechanism. It's 0.125% of the goods as soon as they arrive in the port, paid by the shipper. So that's something that you talk about with taxes. It's too complicated, and this is something that is, for taxing purposes, very simple. And it applies to all major ports within the United States, with the exception of Alaska and Hawaii. When passing this act, Congress realized that of all the imports that come into those two states, they really depend more on their port use than other states within the U.S. So to impose a tax would possibly be a little overly burdensome for them. Now, all of the money that's collected by the Harbor Maintenance Tax goes to the Harbor Maintenance Trust Fund. And ideally, what's supposed to happen is that all of that money is spent directly for maintenance and dredging projects. Unfortunately, that's not what happens. And that's a lot of the scope of my comment, is talking about how we can address this problem where we're collecting this money for a specific purpose. It's being used for that purpose, but it's not being fully used for that purpose. I'll talk a little bit about the case law history dealing with the Harbor Maintenance Tax. And I won't bore you with the niceties of constitutional law too much. And the comment will be available in full text in Volume 38, Issue 1, which is available at Tulane Maritime Lawjournal.org as well. So the first major case, the Supreme Court case, was a case called International Shoe. And as I mentioned before, as originally enacted, HMT applied to both imports and exports. Unfortunately, there's something called the Exports Clause in the Constitution, which prohibits Congress from imposing any tax on exports. So you cannot impose a harbor maintenance tax on exports in the wake of International Shoe. And this is potentially a pretty big blow.
The meeting is about to end in less than 10 minutes.
But there was a significant revenue stream that could have been coming in that no longer comes in.
The meeting has been extended by the moderator.
Cruise lines and Princess Cruises. And the HMT also applies to cruise line passengers, and it's assessed based on the value of the tickets that the passengers purchase. So it's 1.25% of all of the passengers times the ticket price. And in these two cases, the HMT was upheld. Export clause didn't apply because all of us sitting in this room are not exports. And if we do become export, we're in a very bad situation, and we hope that doesn't happen. And also the court held that the export clause the export provision of the HMT was severable from the rest of the statute. So therefore, in the statute as a whole, did not fail. And then, of course, other people got greedy and tried to piggyback on International Shoe even more and tried to strike down the HMT as applied to imports. And the two main arguments they opposed there were first the severability argument, which had already been decided and was summarily dismissed. And they also argued that because the HMT does not apply to Hawaii and Alaska, that it violated the Port Preference Clause. And what the Federal Circuit did was piggyback off of some Fifth Circuit case law saying that the Port Preference Clause does not apply if this preference is imposed solely on the basis of a geographical limitation, Hawaii being way out there in the Pacific and Alaska being way out there in Alaska. There were some geographical limitations that they were exposed to. So that's where the HMT stands today. It's a tax on imports, 0.125%, pretty straightforward, right? So there have been some recent developments to kind of revitalize this tax and to make it more successful and have a larger impact. And currently, the U.S. we impose about $1.6 billion that we collect from the HMT every year. And in the Harbor Maintenance Trust Fund right now, there's a surplus of over $8 billion. So that's $8 billion that could be going out there for improvements to our ports and harbors that is sitting in the General Treasury, not doing anything with it. And every year, when the HMT is appropriated or the HMTF is appropriated, it's usually only about 60% of the total funds that are collected. So as you may imagine, several acts have been, or proposed legislation has been put forth to deal with this issue. And one of the recurring acts that is continually reintroduced is called the Realize America's Promise Act. America's Maritime Promise Act, aptly named the RAMP Act. And what that contains is a guaranteed spending provision saying that every year Congress cannot even look at a bill unless it fully appropriates all of the HMTF, receipts plus interest that are collected from the harbor maintenance tax in that year. And there's also another act that was discussed. I don't know if it's back right now. It was introduced when I wrote the comment a while ago. It's the Corps of Engineers Reform Act, and what that would do would radically transform the HMT into a block grant that would be administered by the states. There's not a lot of support behind this act, but one facet of it that may be potentially pretty interesting is that it expands the definition of what the HMT funds can be used for, as opposed to just solely maintenance and dredging operations. It expands that to more, other projects within ports and harbors. And just this summer, as this comment was being edited, the Senate passed the 2013 version of the Water Resources Redevelopment Act, which was the original piece of legislation that the original HMT was passed within. And what that includes, most of all, is another enforcement spending guarantee saying that the level of receipts plus interest must be spent every year from the Harbor Maintenance Trust Fund. So we don't have this huge surplus building up that's just sitting there not doing anything. And another mechanism within that is it creates a mechanism prioritizing which ports receive these funds. It's kind of an equitable mechanism. They need to contribute a certain amount to the Harbor Maintenance Trust Fund every year, and it prioritizes which ports and harbors receive funding based on which ports and harbors receive funding in the prior years. So we're not pouring tons of money into New Orleans, which doesn't usually happen, or any other port for that matter. There's also been a House resolution that passed that was just introduced in May that mirrors another guaranteed spending provision. So obviously this is an important topic that people are talking about this tax. And actually just a week ago, the two senators from Washington introduced a proposal to completely revamp harbor maintenance tax and replace it with something called the Maritime Goods Movement User Fee. And what their concern is that shipments that would usually be coming into Washington State, Tacoma, and Seattle and those ports are going up into Canada because of the harbor maintenance tax. There have been some studies out there that kind of refuted this claim. Not kind of, did refute this claim. But nonetheless, this was just introduced. There's really no information about how the user fee would be structured, which is obviously very important. For efficiency's sake as well, it'd be tough to impose something that's a little more complicated on a piece of the economy that's always moving. You always see ships coming down this river. It would be tough. So I talk a little bit about my proposals for reform for the tax, and obviously the main thing is to pass some sort of guaranteed spending provision. There's no use collecting all this money and having it sit there. And when you look at what people complain about when they talk about taxes, you're saying, I don't know what my money is going to do. And the way that the HMT is set up deals with that problem. You have this tax. It's something that you use. If you're importing into this country, you're using the ports and harbors. You're paying this tax to revitalize the ports and harbors, to dredge. And that should it make it a little bit easier to pay it. But that's kind of undercut when you're paying this money and it's just sitting there. So obviously, creating a mechanism where Congress is more or less forced to spend this money is something that's the first step, but also a potentially very big step in this process. Another thing I talk about is expanding the use of what these funds can be used for. As it is right now, it's solely in maintenance dredging, but there's so many other portions of our ports and harbors that need revitalization as well. And to think that the U.S. can spend $8 million plus the $1.6 million each year solely on dredging, you can't just throw all that money out there and think it's going to be used on one project. And we have cranes, gantry cranes, and bridges and tunnels and other parts of the infrastructure within our ports and harbors that really, it does need revitalization as well and to take some of that money that's collected from the H&T and give it to those projects is something I think would be very beneficial. And it would also spur public and private partnerships. There's been a lot of, a decent bit of private investment in those projects. And if you get a little bit of public investment as well, it may spur some private investment along with that. The user fee, as I said, is a little too complicated, in my opinion, to completely revamp this tax. It is a simple tax right now. It's just something that probably doesn't have the best chance of passing, and that's probably a good thing. So in the end, what the harbor maintenance tax is, and I said, it's a simple mechanism. It's for a specific purpose, and it's for a purpose that benefits the people who pay the tax. So it's very potentially useful going forward, and it's something that that needs to be addressed for this infrastructure investments that we need. And as soon as we invest in these, this means more maritime commerce, which means more maritime law, which means more work for maritime lawyers, which is, I think, that everybody in this room can agree is a good thing. Thank you.
Good evening. I'm Caroline Frilot, and I wrote my comment on Lozman versus City of Riviera Beach, a recent Supreme Court case that came down. And I really wasn't sure what I was going to write about. I had talked to Professor Davis for a little while about pirates, and then our comment topics were due January 30th, and then on January 15th, Lozman came down from the Supreme Court, and it was like fate. And I got in touch with a wonderful mentor, and he told me, go look on LinkedIn and see what they say about the case. And so I went and looked, and from LinkedIn, it was the apocalypse. Maritime commerce was going to come to a complete halt. The roof was just falling, caving in, and everything was going to be terrible. And so I was a little skeptical of this overreaction, or if it was an overreaction. So I decided to focus my comment on the effects of Lozman and if they were going to be as bad as everyone said. And I came to the conclusion that Lozman is actually, in some aspects, a good thing, and it is by no means catastrophic. So Lozman is very important because it's a case about vessel status. And vessel status impacts so much in the maritime industry. It can impact available tort remedies. It can impact ranking of creditors. It can impact insurance coverage. So knowing whether something is a vessel is crucial. Now, vessel status usually turns on the interpretation of the statutory definition of a vessel, which is any watercraft or artificial contrivance used or capable of being used for transportation on water. Now, this has been an issue for decades, but became heavily litigated in the past 10 to 15 years. And the Lozman decision specifically came on the heels of another Supreme Court case, Stewart v. Dutra Construction Company. And Stewart and its progeny are crucial to understanding Lozman. Now, Stewart was important. Stewart made sure that when you consider the vessel status test, you focus on the craft's capability, whether it is actually practically capable of transporting people and things across water, rather than theoretically, in some philosophical way, possible as a means of maritime transport. But the problem with Stewart is that for years, especially circuits that do a lot of maritime practice, those circuits had developed their own vessel status tests. And so the question became, what does Stewart do now? Does it become a jumping off point where we consider Stewart and keep using our own test? Or does it abrogate everything and create this broad definition of what's a vessel? Essentially, everything that floats could be a vessel under Stewart. So the circuits got confused. And one thing led to another, and some circuits began considering some factors that were very detrimental to maritime commerce. Specifically, they began considering an owner's intent. Take, for example, someone gets injured on a moored vessel or a moored boat. All the owner would have to do is file an affidavit saying, my vessel's moored, I intend to keep it moored, I intend for it never to sail again. And courts would consider this as evidence of whether or not it's a vessel, because it wouldn't sail. And this was a real problem. And this is why the Supreme Court considered Lozman. The Supreme Court wanted to resolve this and remove this subjective element that put everything in a little bit of flux. And so the Supreme Court granted cert on Lozman to remove a subjective test. And they did so through the now infamous reasonable observer test. And the reasonable observer test sounds subjective, but in reality, it's what has made all these lawyers freak out and think the end is near. But in reality, the Supreme Court uses the reasonable observer test when they're trying to make an objective test. They use it in establishment clause cases, in recusal cases, in copyright infringement, in statutory interpretation, and they do it for the specific reason of removing subjective elements from an inquiry. And this is very important because this is the view that we need to take of Lozman, is that it's narrow and that the purpose of it was to add this reasonable observer element to remove subjective intent from the vessel status inquiry. Now, the case may be that there's minimal impact on maritime industry because this is just a narrowing of Stewart. But where there is going to be impact is, ironically, with dockside casinos, which is ironic because that's where the whole vessel status question became an issue. And it started with a case called Pavone. And in Pavone, the court suggested that if an owner intends that his casino boat may never again sail, then it's not a vessel, essentially establishing casino boats, moored dockside casinos, as a class of non-vessels as a matter of law. And after Pavone came out, tons of courts issued decisions stating the similar proposition that this is a dockside casino, it's moored, therefore it's not a vessel. In one of the cases, the vessel in question could be unmoored and ready to sail in 15 minutes with no problem, inspected by the Coast Guard, but the court ruled it not a vessel because it was a moored dockside casino and a non-vessel as a matter of law. And this is what was so problematic. And Lozman has completely done away with this and said this is not acceptable and this is not a predictable way to look at a vessel. If the casino boat really can't go out and sail, that's when it's not a vessel, not because of the owner intent. So casino boats may have some serious impact from this decision, but otherwise it's a good thing. It's not the apocalypse. It doesn't occur all the time because 95% of what you see out there, these boats on the river, they look like a vessel. You know it's a vessel. There's no doubt in your mind that it would be a vessel. It comes in these 5% of cases where you have the dockside casino, you have Mr. Lozman's weird houseboat, of which there was no parallel structure in the entire country. It was a plywood thing with French doors built on something that floated, and there was nothing like it. And so that's when this inquiry comes into play. It's not very often, and it's a good thing because it eliminates this potentially detrimental subjective intent test. Thank you.
Good evening, everyone. My name is Phoebe Hathorn, and I chose to write my comment as a case study analyzing the differences in cross-border insolvency in the maritime context. And I chose to write on this topic because in researching U.S. cross-border insolvency law, I saw a lot of publications out there that discuss the different provisions of these statutes. But I never really saw any publications that apply these statutes in the maritime context. As a result, I fashioned my comment as a case study analyzing the differences between how two countries the United States and Singapore would handle cross-border insolvency proceedings within their boundaries. So taking a second just to step back, what exactly is cross-border insolvency in the maritime context? And I'll answer that question by posing a bit of a hypothetical situation. Let's say you have an international shipping company that is based in the United States. That's where it is incorporated, that's where its headquarters are, that's where its administrative offices are. And among its assets include vessels that travel the world, that go to ports and transport cargo. At some point, it began facing financial difficulties because of increasing oil prices, because of a decreasing demand for various goods, and because of an oversupply of ocean-going vessels. And as a result of these financial difficulties, it's forced to institute bankruptcy proceedings and chooses to do so in the United States. In the meantime, one of its vessels that's visiting various ports is arrested in Singapore. So what is Singapore to do now that it has arrested a vessel that is involved in a bankruptcy proceeding in the United States? Should Singapore maintain its authority and jurisdiction over the vessel and use the funds that it acquires through that process to satisfy its local creditors? Or should it instead transfer its authority over this vessel back to the United States, where the foreign debtor is also already going through bankruptcy proceedings? So this hypothetical sets the discussion for the two main approaches that are taken towards instances of cross-border insolvency. The first one is called Universalism. And the ultimate goal of Universalism is to have one unified proceeding that addresses all of an insolvent company's debts, obligations, etc. It's one single bankruptcy proceeding in the debtor's home country where a single court applies its own laws and makes a unified worldwide distribution to creditors. It makes sense. Bring all creditors to the same table so that all are treated as they should be. So you can see the benefits of such is to ensure that all creditors are given the treatment that they deserve. At the same time, it promotes judicial economy because as opposed to having insolvency proceedings in 5 different locations, you have one that address all issues. On the other end of the spectrum, you have a theory called Territorialism. It's based on the notion of national sovereignty. And instead of having one single unified proceeding, any assets that a jurisdiction can get its hands on should be within the exclusive jurisdiction of that country and should be used to satisfy the claims of its local creditors. So you can see that there are two major different theories as to how you should address the situation. As opposed to universalism, territorialism can sometimes be a bit faster. As you can imagine, waiting for all parties to come to the table for one unified proceeding can take time. So territorialism often results in speedier resolution, and you're also not dealing with power struggles. Rather than having to wait for another jurisdiction to transfer its authority to you, you address whatever assets you have within your reach, and then you move on. So you may be wondering which countries subscribe to which theories. The United States, for one, is relatively universal. Along with 19 other jurisdictions, including the rest of North America and Great Britain, the United States incorporated the provisions of the United Nations Committee on International Trade Law's Model Law on Cross-Border Insolvency, which is located in our U.S. Chapter 15 bankruptcy law. The entire goal of this model law is to promote coordination and cooperation among the various courts in different jurisdictions. As opposed to a comprehensive scheme, the model law is intended to only focus on key areas, and that is encouraging cooperation, encouraging comity, and also facilitating the recognition of potential foreign representatives who might be working in the court system. And you may have noticed that I keep on using the term model law as opposed to conventions or treaties. The UN committee was very specific in using a model law because of flexibility. This enabled countries that wanted to enact these provisions to make their own changes. They could add provisions, they could remove provisions, change terminologies and things of that matter. For example, some jurisdictions chose to insert reciprocity provisions, whereby they will only offer the benefits of the model law provisions to other countries who offer the same benefits to them. The United States pretty much adopted these provisions as they were presented by the UN committee. And as far as the provisions are concerned, many of them are procedural, but the key provisions relate to the types of relief that are available under the model law. So, for instance, when the United States is approached about recognizing a insolvency proceeding occurring in a different country. For example, you have a Singapore company that has instituted proceedings in Singapore, and they are trying to protect their United States assets. If the United States sees that this foreign proceeding is in the company's center of main interest, such as where it's incorporated or where its headquarters are, it will recognize the proceeding as a foreign main proceeding, and as a result, it will give it an automatic stay against any pending U.S. litigation and also prevent the execution against any assets located in the United States. If instead it sees that the foreign proceeding is pending where they have an establishment, but not necessarily where their center of main interest is, they will recognize that as a foreign non-main proceeding. And while they still may be entitled to the same forms of relief, it is within the U.S. court's discretion as to whether or not that type of relief will be recognized. And lastly, there are instances where it may not be recognized as a foreign main or non-main proceeding, in which case the United States court would not offer any forms of relief to the foreign debtor. So you'll see that while the United States is relatively universal in their approach to cross-border insolvency, there are remnants of territorialism in our laws. At the other end of the spectrum, we have Singapore, which is definitely the poster child of territorialism. And you may be wondering, why did I choose Singapore of all of the countries to choose from? Of the countries which have not enacted the UNCITRAL model law on cross-border insolvency, Singapore is the only one that speaks English and has statutes in English. So as I did not want to learn a second language for this experience, I chose to go with Singapore. Though they have not incorporated the terms of the model law, Singapore does have an extensive regulatory scheme that goes over instances of cross-border insolvency. Their whole practice boils down to something called ring fencing, where the foreign debtor is forced by statute to consolidate all of the assets in Singapore for consolidation. And after the cost of the insolvency proceedings are paid, the funds are then used to pay local creditors to the exclusion of any other potential creditors. And if any funds remain afterward, those are transferred back to the debtor, who can then use those funds for any other pending insolvency proceedings they have in other countries. While there are other options available, for instance, seeking recognition of a foreign judgment in Singapore, which has worked in the past, ring fencing is by far the most popular approach that is taken by Singapore. And commentators speculate that Singapore's approach to cross-border insolvency is not likely to change. They have more pressing political and social issues. They already have an existing insolvency regime which has addressed all of their problems so far. And also a question presents itself as to who really benefits from being universal. Are they the larger, more powerful countries, or are they the smaller, weaker ones? So by being territorial, Singapore in a way protects itself by ensuring that no matter what other parties are at the table, that they do have power in the situation. So in conclusion, every country has a way that they address instances of cross-border insolvency. It does not mean that one approach is necessarily better than the other one, but depending on where a vessel is arrested, it can make a big difference as to whether a creditor gets paid, and if so, when that occurs. Thank you.
Good evening. My name is Imran Naeemullah, and I have the somewhat dubious honor, because we're going in alphabetical order, of being the last to present on a Friday evening here in New Orleans. So thank you for being here, and I promise I'll try to be as brief and hopefully interesting as possible. So I began looking at this topic when I talked with Andrew DeClercq, who's an adjunct professor here at Tulane Law School and a partner at Frilot here in New Orleans, and he mentioned that I should consider looking into indemnity in the maritime context, and maybe specifically at offshore oil and gas, because there's a lot going on and there have been some recent developments in the area, which I will discuss with you in a few minutes. I thought that sounded like a pretty interesting concept and very relevant. You look outside, well, not directly, of course, we don't see oil and gas, but very close, right here in our own backyard, there's a lot of production going on. So I decided to write about the topic, and I met also with Professor Robert Forrest here in Tulane Maritime Law Center, and he suggested that this was in fact a good topic, particularly if I focus on oil and gas in the offshore industry, and also looked at a couple of permutations that are not necessarily troubling, but that can pose some complications for practitioners, such as defining what is gross negligence. So my comment really isn't so much a persuasive piece. I'm not trying to advocate per se that the law should change, but I'm really trying to set out a guide to practitioners in the offshore oil and gas industry here in the Gulf South as far as what are some of the major obstacles that they would face when they're trying to enforce an indemnity agreement. And the reason for this, of course, is that indemnity is central to so many things that lawyers, not just in this industry, of course, but many industries do. And so I felt it would be helpful to highlight these obstacles and point out maybe a few areas that could constitute an exception or ways to smooth things over and increase the likelihood of a provision being enforced. And so the three main obstacles I focus on are: 1, statutes; 2, what I call responsibility shifting, but it's really about who's going to pay first; and then third is public policy exceptions to enforcing an indemnity agreement. And so the first I'll talk about is statutes. And the short answer really is that it depends on whether it's federal or state law. If federal substantive law governs, then generally speaking, indemnity is going to be allowed. Whereas if state substantive law governs, there's a very good chance that the indemnity will be disallowed, or in other words, prohibited by statute, which obviously would constitute a barrier to enforcing the provision. So when is it federal law? In the offshore oil and gas context, the most obvious statute to look to is the Outer Continental Shelf Lands Act, or OCSLA. And if OCSLA applies, then it does permit indemnification. But when is OCSLA going to apply? Well, in the past, that was a difficult question. The Fifth Circuit had a fairly complicated test for what constitutes an OCSLA situs. But fortunately, 3 years ago in 2010, sitting en banc, the Fifth Circuit changed that approach. And the case is called Grand Isle Shipyard versus Seacor Marine, 589 F3D 778. And in that case, the court changed the approach and made it something very simple. It changed it to a focus of the contract test. And what you do is you look at the contract and you look at the work contemplated by that contract. And if the majority of the work is maritime in nature, you have an OCSLA situs. And you have, therefore, OCSLA applicable and the indemnity is allowed. And by implication, then, if it is minority maritime work, then you don't have OCSLA situs and you don't have a OCSLA application. Judge Garza, leading the dissent, disagreed that it's quite this simple. For instance, he pointed out, if you take the word majority, what does that mean? How do you define majority maritime work? And so that's one complication he pointed out. But in looking at this, it does seem that it certainly simplifies the law considerably and makes it a lot easier for practitioners to determine in advance and therefore advise their clients, is this contract going to be an OCSLA situs? Is it maritime in nature? But if that does not apply to you, we're now going to look at state law, and that's where things get a little bit trickier. I focused on Louisiana and Texas for the simple reason that that's where most of the offshore oil and gas work takes place in this country. The vast majority of this country doesn't have offshore oil and gas for obvious reasons, and so many, if not most of the cases are right here in the Fifth Circuit. And so looking at Louisiana and Texas, they both have anti-indemnity statutes, slightly differently named, but they essentially come down to the same general principle, which is leveling the playing field for everybody in the industry, particularly to support or to protect smaller operators in the field. There are many, many risks associated with drilling for oil and gas offshore, and so consequently there's a lot of potential liability that businesses are exposed to when they undertake that kind of activity. And as they sign indemnity agreements, particularly if they're a smaller concern, they could potentially be exposed to amounts far greater than they would ever be able to pay. So the purpose of the anti-indemnity provision is to, in Louisiana and Texas, is to prohibit it if the indemnification is for negligence arising, for personal injury arising out of negligent actions. And Louisiana adds a permutation in that it also arises out of, if it arises out of strict liability or fault. And Texas further protects its businesses by adding damage to property. So in both cases, both states, it's personal injury, and Texas adds a property damage element to it. And so if your claim falls under that, and there's a very good chance that it will, you cannot enforce your indemnity provision in that case, again, if the state substantive law applies to the case. But let's assume that you have OCSLA applicable, so you're governed by federal substantive law. Well, you passed step one, congratulations. But there's two more steps to go, and that's where things can get a little bit trickier, and really where I focus most of my comment on. The second step is responsibility shifting, and I use this word because I think it sort of conveys the idea of shifting responsibility from one party to the other. But really what it's about is what has primary status, the insurance obligation or the indemnity obligation. So when you have the contract, you'll have those two provisions among many others. And if you have the indemnity, presumably you've negotiated that because you want to seek protection from another party for any tort for which you might be liable. And so theoretically, you've drafted that hoping to get all of the coverage. But the problem is that you also have the insurance provisions, and maybe the negotiation results in your agreeing to supply insurance for a particular amount, say the first $500,000 of claims. And so you would then potentially be on the hook for the first $500,000. But at the same time, you've negotiated this indemnity provision. And depending on how the contract is written, maybe you're really thinking the indemnity provision would come in first. Maybe there's a lot more, simply more to that provision. However, the Fifth Circuit doesn't look at it that way. Starting with a line of cases beginning with Ogia versus Laughlin Brothers, which is 622 F2D 186, the Fifth Circuit has held that you must interpret the principles together. In other words, you have to read the contract as a whole, and you can't only focus on the indemnity provision and say, well, you owe me this much because we agreed to it. And the Fifth Circuit has subsequently reaffirmed this position in a number of decisions, including another important mid-1980s case, Tullier versus Halliburton Geophysical Services, 81 F3D 552. And again over the years, the Fifth Circuit has revisited this issue, examined it in a few different contexts, and has almost always returned to the same basic principle, that you must read the contract together and you can't simply focus on the indemnity provision and say, I want to collect my indemnity, please. And so that does pose something of a wrench for practitioners when they're trying to advise their clients, then, well, this is why this provision may not hold up, or why only after a certain amount of money has been spent will it hold up. And it's problematic, of course, for the client because they don't want to use their insurance for the same reasons that you and I wouldn't want, for example, claim on our homeowners or automobile insurance, because it would affect your claims history, it could affect your ability to procure coverage in the future, and numerous other factors, including your premiums. So ideally, you would like the other party to pay and to reimburse you for any amounts that you are liable for. So that's where the Fifth Circuit's reasoning has problems, depending on whose side you are. Of course, if you're the indemnitor, in other words, the person who has to pay out, you're happy. And this is perhaps what you also contemplated, is you don't want to be on the hook for the first X dollars that it is, whether it's $500,000 or any other number. And so, of course, it all depends on your perspective. And that's why I don't really take too much of a strong position in saying the law should be changed this way or that way. Certainly there are complications to it, and I think it would be helpful if there would be greater clarity in certain areas. But I don't take the stand of advocating we should absolutely move this, because I think it's first and foremost, as a preliminary step at least, important to fully comprehend where the law lies and what possible exceptions there are. And on that note, there are a couple of exceptions that the Fifth Circuit has delineated to this principle of reading the contract together. And that's when the insurance obligation is for a limited coverage. So there is one case, for instance, where the Fifth Circuit looked at a contract where there was a workers' compensation exclusion in the contract. And what that meant was that although the indemnity had to provide certain levels of insurance, there was an exclusion for workers' compensation claims. And that, of course, is going to be a lot of what you have in the tort context in offshore oil and gas. And the court held in that sense, it distinguished OGIA specifically, saying that because OGIA did not involve the workers' compensation exclusion, OGIA did not apply, and therefore the court is not bound by the contractual and insurance interpretation provisions or aspects of OGIA. And then in a second case, the Fifth Circuit said that where additional insured status is limited only to risks assumed by the indemnity, that also limits the coverage sufficiently that OGIA doesn't apply. So again, where you're really limiting the coverage to such a narrow extent, the Fifth Circuit has held that OGIA and Tulane do not apply, and therefore you're not bound by those contractual interpretation principles. I think that it seems that what this really tells you is that although the general rule holds true, it seems clear that the Fifth Circuit will enforce the indemnity even if the insurance coverage has not been exhausted when it's not possible to exhaust the insurance coverage because the policy won't allow it or the contract doesn't call for it. And so that's where things stand if you've passed the first statutory hurdle and have now passed the second hurdle of financial responsibility. In other words, if there's no barrier to an indemnity and you've now triggered the indemnity coverage such that the indemnity is paying rather than the insurance, there's a third and final major barrier to enforcing your indemnity provision, and that's public policy. And that's where I focus in this comment, particularly on gross negligence, because gross negligence is a very broad and almost somewhat nebulous area. I believe it's the North Carolina Supreme Court has called it as occupying a twilight zone between ordinary negligence and intentional harm. And it's very hard to really define what exactly constitutes gross negligence. If you look at it on Westlaw or Lexis, you'll see many courts have cited many definitions, but there's no one single crisp definition of gross negligence, particularly not in this context of offshore oil and gas and indemnity. And so my comment focuses on different definitions, whether it's in the maritime context or in the international law context, looking at current UN resolution, or current UN treaties, and then potential UN treaties that might be passed, how they look at it. And then I also look even in the criminal law context at looking at precisely what constitutes gross negligence or a close equivalent of it. So even looking, for instance, at the model penal code. And I try to point out some of the differences as well as the many similarities between these varying definitions. And the reason it's important is something that will become apparent in a moment when I discuss whether gross negligence is, whether the liable party's actions are considered grossly negligent. And defining that is really what matters. Historically, the Fifth Circuit has not allowed indemnification against gross negligence. There is a long line of case law that says you cannot indemnify against gross negligence. And perhaps the most obvious reason is that if you're grossly negligent, it's meant more than simply ordinary negligence. It's getting closer to intentional harm, which is exactly what that court was probably thinking of when it said it occupied the twilight zone. And so there's an idea that you should not be able to get indemnification for this. But that's changed, at least somewhat. Judge Barbier, in one of the decisions issued in Deepwater Horizon, found that you could, in fact, indemnify against gross negligence. And I'll give you the cite for this because there are numerous decisions on this case. It's 841 F Sup 2D 988. And it's about 24 pages of what I think is very carefully reasoned analysis of why Fifth Circuit precedent does not bind the Eastern District of Louisiana to disallow indemnification against gross negligence. And Judge Barbier sets out numerous reasons, but his biggest reason, his primary reason, I think most persuasive reason, is that all the Fifth Circuit precedent and other circuit precedent that deals with this issue really addresses releases. And Judge Barbier goes to considerable lengths to explain the difference between indemnity, or what he calls true indemnity, and release. And he says even though some of these other decisions have used the phrase or the word indemnity, what they really meant was a release, wherein one party absolves the other party of liability. But an indemnity, a true indemnity, is where the party actually agrees to be reimbursed for amounts it is liable for. And this, Judge Barbier held, was the critical distinction. The Fifth Circuit has not actually disallowed indemnification against gross negligence in the true indemnity context, and therefore Judge Barbier found this to be an issue of first impression that he could decide. And he set out three other reasons that this finding is not incongruous with circuit precedent. And the first is that the parties are sophisticated entities with freedom to contract. In other words, they know what they're doing and they're free to contract for what they want to contract for. And Judge Barbier explained this is one reason that I find this to be a reasonable interpretation. The second, and this is thinking back to the public policy reasons that ostensibly underline disallowing this type of indemnity, is that the financial obligations of indemnity, as opposed to release, instill safeguards against reckless behavior. In other words, if a party knows that it will be financially liable to another party in certain situations, it has a literal economic incentive to not engage in that behavior, whereas if it has a release, there's not so much a direct economic incentive. And this, Judge Barbier felt, was persuasive. And then Judge Barbier arrived at a third and final reason that this is not inconsistent with Fifth Circuit precedent, and he uses those words, not inconsistent with the Oil Pollution Act of 1990. And Judge Barbier points out that although OPA does not explicitly allow indemnity against gross negligence, there is one section in which it states that a certain type of indemnity is not allowed, but then in another section addressing indemnity, it's silent as to gross negligence, and therefore Judge Barbier reasoned it's not inconsistent with OPA, a federal statute, to allow indemnification against gross negligence. Now, of course, where we stand at the end of all this is that it's a district court decision at the end of the day. It has not gone up on appeal. As far as I'm aware, there have not been any cases that have tried to apply this principle before the Fifth Circuit, but there may well come that time. And I think that's where there's some uncertainty right now, because ostensibly you could take Judge Barbier's decision in Deepwater Horizon and write a contract accordingly, and you could advise your client you will be able to get an indemnification against gross negligence, and the court, at least here in this district, will enforce it. But that's not certain. So that's where there's some uncertainty. And so to the extent I would advocate particular direction, of course, is for judicial reassurance that contracts or contractual provisions like this will be enforced, or conversely to say that they will not be enforced, but again to provide clarity for parties so that they have a greater sense of what they're getting into. Despite Judge Barbier's groundbreaking allowing of indemnification against gross negligence, he did continue a couple of traditional public policy exceptions. So these are still barriers that exist even if it's okay to indemnify against gross negligence, and that's punitive damages and civil penalties. And that's much more in line with the traditional rationales, public policy rationales, for not allowing these indemnities. And the reason is that punitive damages have a punitive effect. They're meant to deter a party from engaging in an action. And if they can shift financial responsibility for paying for those actions to another party, then that obviously minimizes the deterrent effect that is intended in the first place by punitive damages. And then civil penalties, although they are monetary and therefore somewhat resemble tort liability or civil liability, they're actually more analogous in their context to criminal liability. They're meant to be a sort of punishment for actions that are against the law. And therefore, Judge Barbier held that there is still a public policy exception to this. You can't contract or you can't assign to a third party your own responsibility or your own liability for civil penalties. And so those two barriers still clearly stand in this circuit and in others, and therefore public policy remains a distinct barrier despite sort of a broad gap opening up in terms of allowing indemnification against gross negligence. But again, defining what is gross negligence is still an open question. As I mentioned, my comment explores some of the possible definitions, but Judge Barbier, at the least, did not define it, and that remains an open question, certainly, as to whether, in that case, even there was gross negligence. So again, there is possibly more room for further scholarship, certainly, and then, again, more room for a court decision to hopefully give some finality to this issue. Overall, the current state of the law makes things somewhat uncertain in the offshore oil and gas industry. There's clearly a lot of precedent, but there's also certain questions, and there, it seems, is not necessarily 100% or even 98% certainty as to whether certain provisions will be enforced or will not be enforced. And that, I think, is some of the problem with the way the train currently stands. And again, as I mentioned, some of the problems are is it gross negligence, and will the Fifth Circuit affirm Judge Barbier's holding? But in closing, I don't advocate a specific change in direction. What I really do with this comment is I hope to identify some of the obstacles that practitioners face when drafting contracts for offshore oil and gas clients, and hopefully provide them with some insight into how to navigate around those. Thank you very much.